On the Tribunal's own initiative, the Tribunal is considering striking out the claim because the Tribunal considers that it is no longer possible to have a fair hearing in respect of it, in light of the facts that criminal proceedings for harassment are expected to be brought by the Crown Prosecution Service against the claimant in respect of her conduct towards the respondent and its personnel. The claimant has been instructed by the police not to contact the respondent, which will significantly impede the progression of her claim against the respondent, and the respondent is intimidated by the prospect of contact with the claimant, which will inhibit its resistance of the claimant's claim. If the claimant wishes to object to this proposal, she must write to the Tribunal by the date, that is 14 days from the date these orders are sent by the Tribunal, giving her reasons for objecting or requesting a hearing at which she can give them. That order was then sent to Miss Ashwell, including the background information about the police statements on which it was based. She responded on the 12th of June 2025, although in keeping with the arrangements put in place by the Tribunal, it was not copied directly to the respondent. It is a long response of 14 pages, but none of the 3 issues set out in the strikeout warning has been addressed. In essence, her position is that the case should proceed to a final hearing because of the seriousness of the allegations, but does not say how that can be managed in the circumstances. Load of codswallop. The Tribunal's proposal to strike out my claim on its own initiative demonstrates a grave miscarriage of justice and procedural unfairness. Each point raised by the Tribunal is factually and legally flawed. 26.1 Criminal proceedings for harassment. Both of my arrests were unlawful, selective and retaliatory, based on 8 cherry-picked screenshots, while over 5,000, like I said before, now it's over 6,000, pieces of exculpatory evidence against the respondent and associates were ignored by West Midlands Police in breach of the Police and Criminal Evidence Act 1984, PACE, Code B, Duty to Preserve Evidence, and the Crown Prosecution Service Disclosure Guidance, which obliges the disclosure of all exculpatory material. There is no proven criminal conduct on my part. Relying on alleged criminality to strike out legitimate civil claims abuses the Tribunal's discretion and is a misuse of the Employment Tribunal's powers under Rule 38(1)b and Rule 47, which require decisions to be just, reasonable and proportionate. 26.2 Instruction not to contact the respondent. The alleged police instruction preventing me from contacting the respondent was not a legitimate safeguard, but appears to have been sought by the respondent to delay or obstruct the progression of my employment claim. This was not due to any genuine risk to the respondent's safety, but rather a deliberate tactic to impede my participation. The Tribunal should note that I provided clear explanations and proposed alternative, lawful means of communication, including remote attendance and correspondence via the Tribunal, in order to ensure full participation. Denying me access on this basis constitutes procedural unfairness and demonstrates apparent bias in the favour of the respondent, contrary to Rule 3 of the Employment Tribunal Rules of Procedure 2013, which obliges the Tribunal to act impartially and fairly and undermines my right to a fair hearing under Article 6 ECHR. 26.3 Respondent intimidation. There is no evidence that the respondent was genuinely fearful. This is a fabricated claim of intimidation designed to bias the Tribunal against me. Using perceived intimidation as a rationale reverses the burden of proof and punishes the victim, while shielding those who harassed, defamed and intimidated me, contrary to principles of natural justice and Article 6 of the European Convention on Human Rights, right to a fair hearing. Response to the Tribunal. I responded on the 12th of June 2025 with a detailed 14-page submission addressing the seriousness of the allegations, evidence of constructive dismissal, sex discrimination, bullying, whistleblowing retaliation, and serious criminal misconduct by the respondent, including rape, collusion, witness intimidation, harassment, stalking, perverting the course of justice, and multiple data breaches. The Tribunal's claim that I did not say how the case can be managed ignores my explanations and proposals, including the use of remote hearings, anonymised procedures, and alternative safeguards. This reflects procedural bias, as my legitimate explanations and proposals are dismissed without consideration, while unverified assertions by the respondent are given disproportionate weight in breach of Rules 3 and 31 of the Employment Tribunal's Rules of Procedure 2013, and contrary to the requirement to act fairly and ensure equality of arms. Conclusion. Striking out the claim on these grounds would be grossly unfair, procedurally improper, and contrary to the overriding objective of justice. I will be appealing any such decision to ensure that my claims receive a full and impartial hearing in accordance with Employment Tribunal's Constitution and Rules of Procedure, Regulations 2013, Articles 6 and 8 ECHR, and established common law principles of natural justice.